Yep.
Okay. All right. Welcome to the Issues Committee for the July quarterly meeting. Let me first tell everybody the members of the committee are hereby advised of their duty under the State Ethics and Government Act to avoid conflicts of interest and the appearance of conflict, and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest or an apparent conflict. Okay. So if something comes up during the meeting, please let us know and we will record that in the minutes. Our first order of business is to review the proposed minutes of the meeting of January 22nd, 2020, the last time we were in each other's presence. And I hope you've had a chance to look those over. I would entertain a motion to accept and adopt those minutes. If someone would so move by raising your hand, maybe.
Alice has her hand up.
Darren?
Yes.
I think I sent everybody an email to this effect. Unfortunately, I lost my attendance list for the Issues Committee meeting in January when I wrote the minutes. So I listed everybody as being present. Jerry Collins came forward and said that no, he was not there. But if there's anyone else who is not present at that meeting, if you would so indicate, and then you can adopt the minutes with the attendance corrected.
All right. Other than Jerry Collins, is anybody else on the phone call who was not there? Everett? Anyone else? Mike, you weren't there? Okay. Anyone else?
Darren, this is Gordon Brown. I'm not on the committee. I'm just a visitor. So,
yes, sir. No problem. Thank you.
Okay, thank you.
Anyone else who is listed as having attended the January meeting but it was not? All right. So, Mark, I saw you raise your hand as making a motion to adopt these. You do so with them amended?
I do. I move to adopt the minutes as amended to reflect the attendance we just reviewed.
All right. Do I have a second? Or raise your hand if you have a second, please. All right. Mac gave a second. All in favor, if you'll just raise your hand on the monitor. I don't think we'll have any dispute with regards to this. It appears to be unanimous, Madam Secretary. All right. The next order of business is to discuss the subcommittees that we have who are working on various items. And is Judge Cobb on? I don't see Judge Cobb. Okay.
Yeah, I don't see him on right now, Darren.
I'm sorry?
I do not see him on here right now.
Alex, do you want to give a report with regards to what that committee's doing since you were the staff member?
Sure, I can do that. So we met twice on the subcommittee. The first meeting, we basically just went over the issues involved with compensation of court-appointed counsel, and tried to come up with a meeting state or a subcommittee statement, mission statement. I don't know if we did that exactly, but we started to do that at the very least. I think somewhere in the middle there, when we were trying to come up with the mission statement and come up with the game plan, we kind of realized that we needed to learn some things. I did provide some reading material that was given to me from other committee members. But even with that, we needed to learn something about the IDS process. And so on the second meeting, we had Whitney Fairbanks come and speak to us. She, at the time, was the interim executive director and also general counsel for IDS. And she went over a lot of stuff, basically the inner workings of IDS, how compensation goes on through the state for appointed counsel, and then standards and practices for appointed counsel throughout the state as well. And we all had a bunch of questions. And so that's where we are now. The next meeting that we have, I'm hoping to kind of solidify a game plan to go forward. and see what we want to do specifically with studying this issue, and what we want to do as far as whether we want to do a report or anything else with that product after we do the study.
Thank you. I think Whitney really did a really good job of outlining, because IDS is just not the old method of appointing lawyers to handle cases anymore. It's gotten much more complex. For those of you who don't know, Whitney, who is the interim director right now, will be going back to her old position of general counsel, and the IDS Commission has appointed Mary Pollard, who was with the North Carolina Prison Legal Services Group, as the next executive director. And so she starts August the 3rd. So it may be that if this committee has not completed its work, we could bring Mary in and get some of her fresh ideas also with regards to this important issue. Does anybody have any questions of Alex concerning the work of this committee? I was just checking to see if Judge Cobb had come on. I don't see him. So any questions about that work? Seeing no hands, we will move on to the next issue, proportional discovery. And I think Gray can give a report with regards to that committee. If you want to unmute yourself, Gray.
Thank you, Darren. The initial meeting of that committee occurred earlier this week, subcommittee, for the first time. And we were assisted in that regard by our staff liaison, Carmen Bannon, who's online here and is welcome to contribute to the extent indicated. Preliminary to that charter meeting, Carmen sent some positively lugubrious materials to the subcommittee, consisting primarily of 2015 amendments to the federal rules, which make some inroads, at least in philosophic context, with regard to proportional discovery. At the outset of the meeting, the chair tried to elicit comments about the actual experience subcommittee members had with this concept. And the fact is, there was a dearth of experience in that regard. We have a medical malpractice arbitration statute, which provides limitations on discovery, which are definitely proportional to the extent anyone would participate. But I believe the experience is that voluntary participation in arbitration under that statute hardly ever occurs. So we had to go from that point then to a discussion of what parameters there are for proportional discovery in any of the other rules. And in North Carolina, I believe there's rules of civil procedure essentially have none. Under 26F, you can, I suppose, ask for a discovery conference and try to impose parameters through the court. So that's one mandatory provision that can be pursued, but on a voluntary basis, again, I think it's rarely pursued. So we're relegated then to the federal forum and its cognate rules, and there everybody's familiar with the initial pretrial conference rules, which require certain limits on discovery depending on the track that the case follows, from standard to complex to exceptional. And then there were some amendments, as I indicated earlier, to the Federal Rule 26 in 2015, which talk about at least the concept of limiting discovery abuse and requiring that discovery fall within certain parameters. They give 6 factors in that regard. And it's not only about relevance, but also about burden of providing and producing information in that regard. And I guess I would say those changes are aspirational, at least at this point, but they're not reflected yet in the North Carolina rule. And there was some discussion about perhaps wholesale adoption of that and the mechanism for doing that. Underscoring all of these discussions, however, was the critical question of whether or not it would be the province of the state bar, given its limited regulatory function, to even be involved in this inquiry. And I think Carmen filled us in pretty well about the rules of professional conduct, as well as ethics opinions and actual discipline that has occurred involving discovery abuses, that certainly falls within the parameter of the regulatory function of the state bar, which prompted a further request from her, hopefully not lugubrious materials at this point, but for actual summary of rules of professional conduct, ethics opinions with regard to discovery. And as of this date, I may have come in yesterday, I was out. She has provided those materials, which I hope are being reviewed by the subcommittee at this point. The bottom line is we decided we needed that additional information before having a further meeting in that regard. And again, you know, while there's really not a lot of wild enthusiasm about proportional discovery, certainly not on a voluntary basis, I think the committee will, at its next meeting, try to determine whether or not there is any specific change to a rule or an RPC that we would like to undertake in order to eliminate and reduce discovery abuses. And so at that point, depending on the mechanism we adopt, perhaps we would then launch into liaison with the North Carolina Bar Association, which, as you know, introduces legislation and lobbies for same on a regular basis, and see if perhaps their litigation section might want to get involved and assist us in that regard. So our first meeting was essentially conceptual, but we survived that. And I suppose at our next meeting, we'll actually try to accomplish something concrete. If that's possible, I see there are other subcommittee members that were at that meeting that are here in attendance, like Charles Hardy, and anyone else, you know, wants to add to what I've said, feel free to do so, especially Carmen.
That was perfection. I have nothing to add. Thanks, Greg.
Could you repeat that for the microphone?
I will tell you that Carmen sent out those materials that Gray mentioned, and I got it at least this morning, and they were exceptional. Gave a really good synopsis and summary of what the state bar has done with regards to discovery violations or rules of professional conduct violations. But it also gave a good synopsis of what is in our rules with regards to discovery being monitored. So maybe we could send that out to the rest of the issues committee to kind of take a look at and see what the subcommittee is looking at. And there may be some things that the entire committee, members who aren't on that subcommittee, might want to add. So maybe we could do that before the next meeting. So, but thank you, Gray, for that work. Does anyone have any questions of Gray or Carmen or any of the other members? Charles, and I think Walter was on there, and maybe Heidi was on there, maybe? No, I've seen Heidi on another meeting, but anyway. So any questions?
On there.
Okay. Any
I have a
questions?
question.
Yes, sir.
Would you remind me how this fits in with our mission of regulating the bar? We've had the conversation. I just don't remember what the answer is of why we're taking up.
Well,
Great.
Well, because of the proliferation of discovery abuse, which is, and I think the materials that Carmen provided today will reassure you in that regard. So I think Darren's suggestion that the entire committee receive them would be instructive. It's more extensive than one would think. And the disciplinary matters that come before the grievance, with a couple of very special cases that will remain nameless, are illustrative in that regard.
Okay. Any other questions? Is that Todd?
Hey, Gray, I agree with everything that's been said. One observation, I guess, and one question. I absolutely agree there's no proportionality written into the North Carolina Rules of Civil Procedure. But one way, as you well know, to address discovery abuses is Rule 26C, which allows you to get an order limiting discovery or specifying certain terms. What discussions did you guys have about whether that somehow allows us to get at the proportionality concept?
Well, of course, 26C is, designed to provide a forum for restrictions or limitations on discovery that's proposed. And
Right.
So it's not an abuse necessarily that prompts such a motion. And
Agreed.
if a motion like that is filed, it's up for the court to decide. And I think good cause is still the standard under Rule 26C.
Right.
Whether or not appropriate limitations should be applied. I think the concern is more about abuses that occur not in connection with the motion process before the courts, but in the actual discovery procedures, sandbagging, withholding documents, destroying documents. Abuses at depositions are also prominent on the screen there. So I don't think we had any actual discussion about Rule 26C, but we'll try to plug that into the next meeting.
Well, maybe I misunderstood. I was looking at the materials and the highlighted language in red, and in the federal rules, it refers to proportionality under Rule 26B. And then I didn't see that concept. You're right, under the North Carolina rules. So I assume that we were talking about somehow putting in the North Carolina rules perhaps the proportionality theories that apply in the federal rules. Do I misunderstand what we're trying to do?
No, you don't at all, but it would probably we would be plugging in those 2015 amendments to Federal Rule 26 that discuss basically proportional discovery and the 6 standards by which that's to be assessed.
Okay. All right. I follow you. Thank you.
Any other questions of Gray, Carmen, or the other committee members? Any of the committee members have, or subcommittee have any questions or want to make any comments with regards to your work? Okay. Thank you, Gray, for that report. And thank you, Carmen, for that memo today. It was really good. We'll move to the last subcommittee that we have, which is the report of the subcommittee to study proposed regulatory changes in other jurisdictions. And I will recognize Mark Enrique as the chair of that committee.
Thank you, Darren. We had a really good initial meeting of the committee to study regulatory change. We were disappointed we couldn't meet in person. We were working on trying to do that right as COVID hit, so we decided to meet virtually instead. I think in addition to getting acquainted and talking about our mission, which, just as a reminder, we are a study group, so we are trying to look at all the different regulatory change that's going on around the country with the idea of identifying any that might be interesting for us to pursue further. So, and we started off with a great presentation by Brian and Alice. Brian put together a terrific set of slides going state by state, showing what has happened. Those are in your materials. They're attached at the end of this issues committee agenda. And it was interesting to see the scope of what's being considered and what the overlaps are. If you don't have time to review the whole thing, on page 70 of the materials, you'll see a slide where we consolidated kind of what we felt were the most frequent reform ideas. And again, this initial meeting was really trying to come up with a list of what are some of the things people are talking about that we may want to talk about. So and I'll review a few of the items on that list. One thing that a number of states have experimented with are some kind of paraprofessional designation. Interestingly, Washington State was one of the first. They came out with something called the triple LT, or a limited legal technician. And very recently, their High Court decided to abolish that program. It's interesting. They didn't have a lot of people get the triple LT designation. I think it was maybe 40 people across the state, and it was established several years ago. And the Supreme Court decided to abolish it, finding that it was not worth the money they spent. There's a fairly vigorous dissent from one of their justices saying that the program was working and serving people. It did grandfather in people that already had the triple LT, but they were not making any more. I will say there's arguments on both sides, but the fact that they started it, invested a lot of money, and then canceled it certainly is a warning sign, I think, in terms of going down that road, although it's something several other states are exploring. And again, the idea is, are there some things that you don't necessarily have to be a lawyer to do, particularly if we're targeting at-need groups where we could have something in between a paralegal and a lawyer doing a limited and defined set of functionality. Another area that a number of people have explored with, including other countries like the UK and Australia, is the idea of non-lawyer ownership. This would allow law firms to go public and get investment money from the private sector. The thought is that if that new money comes in, it can encourage innovation and funding and do stuff on a scale that's difficult for a lot of lawyers and law firms to do now. There is continued interest in it. I think right after our committee met at the end of April, the Utah Supreme Court proposed a broad elimination on the prohibition of attorney fee sharing. They also wanted to revise the rule about non-lawyer ownership and create a legal services innovation group. So they are one state leading that effort, but others have also explored that. And then we talked about some other things that are being done around fee sharing, some amendments to the advertising rules. As many of you know, we're already ahead in that regard. We have the advertising revision subcommittee looking at Rule 7 has already provided some changes in connection with referral fees and a specific innovative proposal around intermediary organizations. So North Carolina is actually leading, I think, in that specific area. And then the others are broader ideas around a legal regulatory sandbox, saying, hey, we should open up opportunities for innovation and doing creative stuff under, with certain guidance to try to understand what can be done. Maybe alternative admission to the bar. That's interesting because in COVID, some states have adopted you graduate, you can join the bar, and have waived the bar exam. Obviously, North Carolina is not one of those, but it is interesting, and it's been prompted by some of the difficulties in administering the bar exam under COVID. But some states were exploring that concept even pre-COVID to say, do we really need the bar exam, or what purpose does it serve? So lots of interesting ideas. We are still at an early stage. Our next meeting, we're going to have Bill Henderson, who did a presentation to California and is kind of regarded as the father of a lot of this legal regulatory change, arguing that you can improve access to justice by removing some of these restrictions. He's coming to speak to our committee in a virtual way at the end of July, which is the next time our committee will meet, and he's already lined up. And I think that'll be a very interesting presentation. Our plan is to focus on some education. So we're going to have Bill Henderson speak at the end of the month. Then in August, we're looking at maybe having some of the folks from legal aid come and talk to us. Again, it may be virtual at this stage, depending what happens with COVID, to educate us around the needs in the legal aid community. The main motivator to look at regulatory change is to try to improve access to justice, right? That's the main motivator. I think innovation, and more efficient legal services is kind of a sub goal. But the main goal is to improve access to justice. If we're not going to achieve that, I don't see necessarily great motivation to make some of these changes. So we wanted to hear from legal aid folks in terms of the needs they see and whether they see any opportunities for the bar to ease restrictions that might help address some of those needs. So the next two meetings are still going to be what I would call education meetings. And then I think our goal would be to identify from this list on page 70 or other stuff we hear from our speakers, are there specific things we want to talk about in more depth and really kind of dig in and explore with the idea of identifying any ideas, and there may not be any, but any ideas that we want to kind of then come back and prepare a report to say, we've looked at these 12 ideas, and these two, may be worth further study in terms of actually suggesting some regulatory change. So that's essentially where we are. But I think it's been a very educational and enjoyable experience, I think, for me, and I hope for the other committee members to kind of understand what's going on. I was surprised at the amount of change. There's a map at the beginning of the presentation, and I think it's 14 states, 16 states, that are engaged in some level of change. So it's definitely something happening. And it's not just, I thought it was all West Coast, all California and Washington State. It isn't. And you look at the map, you've got, more and more states are thinking about things. So I think it's good to be aware of what is going on and if there's things that are useful to us.
Thank you, Mark. If you haven't had a chance to look at the materials that the PowerPoint that Brian did, I missed the meeting on June the 4th, I think it was. And the PowerPoint is really informative. I was sort of surprised at the candidness of a lot of the states saying we tried this and it didn't work, as opposed to it did. There are a lot of great ideas out there that have been tried, and it doesn't look like it has reaped the goals or the what they had hoped it had done. That doesn't mean it wouldn't work in North Carolina, and I think we need to keep an eye and make our own decision. We seem to be on the cutting edge of a lot of times of stuff that may not have worked in other states, but it's working pretty good here in our state. Does anybody have any questions of Mark or Brian with regards to the work of this subcommittee? It sounds like it's got the possibility of maybe going past the tenure of Gray Wilson as an officer. And I know that upsets Gray that it would last longer than his tenure as an officer. But
well, with Mark in charge of that subcommittee, will probably last past my life expectancy. But I did have a comment about that. I was surprised to hear that the LLT program had been killed, especially with all the money that was pumped into it. And Alice knows at least 5 years ago on the Paralegal Certification Board, we were looking at that program and a lot of work went into it. And so I have to wonder if one reason that initiative failed was because of resistance from the practicing bar. And if that's the case, I think with all of these other regulatory schemes that are being examined, that might be an underlying factor that will continue to rear its head.
it seemed like I sent out that article, I think, to the bar officers about that issue when they announced that they were not going to have it anymore. And it seemed like there was a real rift between the folks that were in favor of it and the folks who weren't. And they were pointing fingers at one another as to why it didn't meet the goals. So I think that's still going to be up in the air. There are other states that are utilizing some form of that, and we'll just have to examine those and see if those are going to go to the same way. But Brian, thank you for that. That PowerPoint was great. It may be that at some point in time, we may want you to present that to the entire issues committee, just so we can all understand that. I think that's a better way for us to be able to examine what the subcommittee does for all of us. So it was a great deal. So,
I could add too, just to Gray's point, I do think North Carolina, our paralegal certification has really been successful. We've got a lot of interest and buy-in, and thanks to Gray and the other folks working on that committee, I do think it might, make North Carolina a different case for some kind of, limited licensing thing, because we have that body of people that have spent the time to get trained and certified. And I do think one of the major concerns in the Washington program was you just didn't have enough people doing it. And there was this sense of, we spent all this time and money and we got 40 people. It's just not enough. I mean, we already have far more, much larger number already in terms of certified paralegals. So one thing that I think our committee is at least going to talk about, and again, it's certainly premature to say anything would be recommended, is, are there ways to maybe say, if you're a certified paralegal, there are certain things you may be able to do that other paralegals can't do. In other words, being a certified paralegal not only gives you that certification, but might authorize you to draft a document or do some of the other limited functional things or serve a particular community. There might be a room there that would be a good fit for North Carolina where it wouldn't be elsewhere, because we've got that body of folks that have spent the time, gotten certified, and we could give them some additional authority to perhaps ease the burden on some lawyers or deal with certain underserved populations. So that's one of the things I'm looking forward to talking about as our committee moves forward.
Thank you. Are there any other questions or comments about the work of that committee? All right. Before we adjourn, I wanted to give President Willoughby an opportunity to make any comments that you might have with regards to the work or other issues that you might have that you would like us to look at.
And I think the subcommittees, I mean, it's great that the things that y'all are doing are exactly what I'd hope, is that we'd look into some of these issues, see if there was anything that we thought the North Carolina State Bar ought to be involved in or not. And if it were, then we could run things through the normal course to evaluate it. But I think what's going on is exactly the way it should. And we may look at all these things of proportional discovery and regulatory change and not think there's a place for us to weigh in. But thank you all for doing that. I really appreciate it. That's the best I had hoped for.
All right, thank you. And I don't want to be remiss. I want to ask Ms. Christie, as soon to be our president, if you have any comments or any ideas with regards to what we're doing or what we could be doing.
No, not at this time.
All right. Thank you. All right. I want to commend to you guys that you should have received, I believe, a mailing from the IALTA board. I think I got mine Monday, and Mary is on the call with us here. The annual report was really good. It was interesting to read, and I would commend to you guys that IALTA annual report that you should have received in the mail. You have any comments, Mary, you want to make?
No, thank you for mentioning it though. And it went out, I think late last week. So hopefully if you haven't got it, the report yet, you'll receive it soon to your work address if you are there. The only thing I would say is, for us, it was 2019 was really a positive year in terms of income. And unfortunately that isn't the reality that we're facing at the current moment. But we wanted to take the time to go ahead and sort of fully celebrate that positive moment with the report. And then, we'll look forward to sharing more information as we have more information about what is happening now and what is to come for the rest of 2020. So thank you.
All right. I mean, that's a serious access to justice issue that they're addressing with the money from IALTA. And they did a really great job. I thought it was extremely important to get these banks in line who were paying nothing on interest. And Mary and the board really made a progressive and proactive stance on trying to get that taken care of. So before we end the call, Alice, are you there? I know would you like to make any comments? You're muted again. Peter, is
Yeah.
there?
Okay, can you hear me now?
Yes.
All right, well, thank you. No, Darren, I don't have anything to add. I think these subcommittees are doing a great job. The staff support, I think, is excellent. And I think everybody's kind of learning something as we go through this. I wrote a note to myself about having Brian present the PowerPoint, and maybe we can do that at the October meeting. I think that would be really worthwhile to share that information with the full committee.
All right, thank you. And I don't want to steal Alice's thunder, but on a committee meeting the other day, she mentioned, I want to remind you guys that next Thursday night is the virtual social, and it will be two important things. First, we will learn who will be the next vice president of the state bar. And second of all, we're going to celebrate route and his retirement. So when you're with an organization for 40 plus years, that's quite an accomplishment. And I think it bodes and speaks well of either his ability to stay sane during that time, or I think it's more importantly, it's been the leadership within the state bar that make people want to stick around. At least that's been in my experience as a lawyer. So, well, if nothing else is to be said, Everett. Oh, I can't see. Trout fishing. Oh, yeah. I'm sorry, there's no trout fishing this year. But unfortunately, as you guys know, there won't be any trout fishing next year because we're going, unless we fish in the Intercoastal Waterway for it, because we'll be down in Wilmington. So Everett, you'll have to show us how to fish the salt water. So, all right. Anybody have anything else they want to talk about? If you didn't know this, and if you'll bear with me 1 second, I do want to show you something. Everett's wife, because I took them fishing last year, gave me an extremely nice gift, and I wanted to share everybody. I don't know if y'all know, but she's an artist, and she painted me this picture of a rainbow trout for taking her fishing, and it is one of my prized possessions. I want you to know it stays in my office, and everybody who sees it's impressed. And anyway, I wanted to show you that. It was really cool. So anyway, thank you for indulging me on that.